Happy New Year to all my viewers. And today on 2nd January 2025, we would like to discuss in this lecture about the doctrine of unjust enrichment. And exactly the very doctrine of unjust enrichment is although an integral part of Indian Contract Act of 1872 under the very provisions relating to quasi-contract. But now we want to discuss its very relationship with Article 299, Clause 1 of the Constitution. So basically, doctrine of unjust enrichment means restitution and reimbursement of the benefits one received unjustly. So the very doctrine in simply means that no person can get benefit when he has not suffered any loss. And the very definition and meaning of doctrine of unjust enrichment was itself pronounced by Lord Mansfield in the very important English leading case, Moses versus Archie MacFarlane in 1760, and also in another important leading case, and that is Fibrosia versus Fatbone in 1943. Why? Lord Justice Wright. So, in his own words, he defined it as that any civilized system of law is bound to provide remedies for the cases of what has been called unjust enrichment or unjust benefit. That is to prevent a man from retaining the money of or some benefit derived from another person, which is itself is against conscience, which in that very word Lord Wright expressed that genetically different from rebate is in contract or in tort, and are now recognized to fall within a third category of the common law, which was prevalent in England, which has been called quasi contract or restitution, and as it was also being defined under certain important leading cases like Rambuck's Chitangu versus Madhusudan Paul Chowdhury in 1867. So also we found place of the very provisions of doctrine of unjust enrichment in our statutes like Central Excise and Customs Law Amendment Act of 1991. So also it is being defined in the leading case, that is Modi Sugar Mills Limited versus Union of India in 1984 by our Supreme Court. So also, it was again defined in 1996 by our apex court in the leading case Indian Council for and for Legal Actions versus Union of India and others. So also in 1997, the Supreme Court defined what exactly unjust enrichment or unjust benefit in the leading case Mabathlal Industries versus Union of India. So also it was again defined and pronounced by the Supreme Court in 2011 in the leading case Rameshwari Devi versus Nirmala Devi. And now exactly the very relationship between unjust enrichment or unjust benefit in relation to contractual liability of state as provided under the Constitution of India under Article 299 and Clause 1 that we would like to discuss. And in relation to that, the very pronouncement of the Supreme Court in the leading case, State of West Bengal versus B.K. Mandal, where the apex court pronounced and recognized the very doctrine of unjust enrichment in the very words that in all civilized systems of law, proper remedy must be provided to prevent a person from getting unjust enrichment or unjust benefit, and restitution must be allowed in all such cases so as to place the parties as nearly as possible in the same position as if the contract had not come into existence. So, also we found the very definition given by the Supreme Court in the leading case, Damodaran versus State of Kerala in 1976, where exactly it was held by the Supreme Court that in particularly in the leading case, Damodaran versus State of Kerala, it was pronounced by the Supreme Court that the right here is not peculiar to equity or contract or trust, but falls naturally within the important category of cases where the court orders restitution if the justice of the case so requires. And in that connection, court also explained a complicated question of liability, however, arises in situation where the party to the contract has done something for the government under a void contract, but the government has not obtained any benefit under it. In such a case, Section 70 of the Indian Contract Act has been held not applicable. So, another important leading case relating to state of Odisha versus Rajballabh Mishra, where it was held by the Odisha High Court. In that connection, we would like to discuss the very decision delivered by the Odisha High Court in regards to unjust enrichment or unjust benefit, as it was pronounced in the decision. Besides Section 30, Section 65 of the Indian Contract Act 1872 has been invoked in some situations. Section 65 contains an equitable doctrine of restitution applicable to cases where the contract is discovered to be void or when a contract becomes void. For instance, where a contract has received payment from the government under a contract for the construction of a godown, but did not complete the work, the government was held entitled to cancel the contract and also to realize the amount advance through though the contract was void for non-compliance with Article 299 Clause 1, so Section 65 was held applicable to this particular case. So also, would like to discuss some other important leading cases in relating to the doctrine of unjust enrichment, and in that case, we would like to discuss another important leading case decided by the Karnataka High Court, and that is Padi Lakshmaya versus Indian Bank Limited in 1982, where the very fact and issue of the case we would like to discuss. A bank granted a loan to A and obtained a decree. A died during execution. It was found that she was the real beneficiary of the loan since he admitted his responsibility in the matter of clearing dues, and the bank proceeded against she on the basis of Section 70 of the Contract Act. But it was held by the Karnataka High Court that she was not assigned liability to discharge debt, as the transaction, if at all was there, it was between A and C and not between the bank and C. So she did not obtain the loan direct from the bank. Neither Section 70 nor the doctrine of unjust enrichment could be availed of by bank to proceed against C. And also in that connection, we would like to discuss another important leading case relating to unjust enrichment, and that is Mir Abdul Jalil versus State of West Bengal in 1984, decided by the Calcutta High Court, where exactly in the fact of the case an amount was sanctioned under the small irrigation scheme for excavation of tanks. Under this scheme, the beneficiaries were to contribute 55% share of cost and state government 45%. The plaintiff was given works under work orders with assurance that he would be recompensed The plaintiff completed the entire work accordingly. It was held that though no contract was executed as per the provisions of Article 299, Clause 1, that the government was liable to recompensate plaintiff for its share of work. So, in such cases, Section 70 is attracted as it was decided by their Honorable Lordship of Calcutta High Court. So, exactly as it was decided by Supreme Court in state of West Bengal versus B.K. Mandal in 1962, that the basis of liability, three conditions were to be fulfilled before this section could be invoked, and this relation with Article 299, Clause 1 of the Constitution of India, and they are, as per those conditions, the first one that was laid down in this important leading case, that a person should lawfully do something for another person or deliver something to him. And the second condition, in doing so, he must not intend to act gratuitously. And the third condition laid down, the other persons for whom something is done or to whom something is delivered must enjoy the benefit thereof. If the above conditions are satisfied, Section 70 imposes upon the latter person the liability to make compensation to the farmer in respect of or to restore the thing done or delivered as it was pronounced in this important leading case. And now we'll discuss the very decision of the Supreme Court in the leading case in state of UP versus Murali Lal, an officer of the Government Department of Agriculture, who was not authorized to sign the contract on behalf of the government, contracted for a space in the cold storage for potatoes from the department which never came, in suit by the proprietors for damages for keeping the space in the storage vacant. In this particular reading, the Supreme Court rejected the claim even on the basis of Section 70. It was ruled that since the contract was void for non-compliance of Article 299 Clause 1, and being void was also not capable of ratification, which presupposed a valid contract, the government having not delivered any benefit therefrom. So Section 70 was held not applicable to that case. So these are the important leading cases. So in that connection, you would like to repeat another important judgment delivered by the Supreme Court in 1976, and that is relating to Damodaran versus State of Kerala, were exactly in an auction for the grant of license for 1 year to sell country liquor and bhang. The petitioner was the highest bidder, but because of certain interim orders passed in some writ petitions, this bid could not be accepted. But an agreement had reached between the petitioner and the district excise official, whereunder the petitioner were allowed to run the shops temporarily on the daily payment basis, in accordance with the contents of the bid, until the writ petitions were finally disposed of. The petitioner stated the shops but defaulted in payment as agreed in response to a notice from the government for recovery of the amount as land revenue. The petitioners moved a writ petition, claimed there being no contract for non-compliance of Article 299 Clause 1. But the Supreme Court rejected the argument on the ground that the petitioners had derived benefit under the said agreement by actually running the shops. So, these are the fundamental issues involved in application of the doctrine of unjust enrichment or unjust benefit as provided under Section 70 of the Indian Contract Act of 1872 in relation to governments or states' liability in contract as provided under Article 299 Clause 1. So, in our next lecture, we would like to discuss another important principle involving law of contract, and that is quantum merit.